A legal milestone in China's foreign relations. The law on foreign relations of the People's Republic of China came into effect on July the 1st after being approved by the country's top legislature. The law, containing 45 articles and 6 chapters in total, is the first fundamental and comprehensive law governing the conduct of foreign relations in China's history. It sets out the general principles, different functions and powers of party and state bodies, goals and mission, and the system of foreign relations for China. While stipulating the goal of promoting world peace and development, the law also grants China the right to take counter or restrictive measures against acts that endanger China's sovereignty, national security, and development rights. So what exactly is the context and the content of this new law? What changes will it make in China's foreign affairs? And how may it affect other countries, especially major Western countries that have increasingly antagonized China? Welcome to this special edition of The Point with me, Li Xin, coming to you live from Beijing. I'm pleased to be joined from Beijing by Professor Huo Zhengxing with the China University of Political Science and Law, from Shanghai by He Weiwen, Senior Fellow at the Center for China and Globalization think tank, from Ljubljana, Slovenia by Alexander Svetlicini, Associate Professor and Program Coordinator of Master of Law in International Business Law at the University of Macau, and from New Jersey, the United States, by James Nault, Adjunct Professor at New York University. Gentlemen, the warmest welcome to The Point. First of all, let me go to Professor Huo to clarify some of the context and circumstances for enacting this law. This is the first, as I said, fundamental and comprehensive law governing the conduct of foreign relations for China more than 70 years after the founding of the country. What are the contexts for the enactment of this law, Professor Huo?
I think we can evaluate this law from two different contexts. The first is the domestic context. As you know, in recent years, China has become the second largest economy, and China is approaching its goal to build a modern socialist, modern, prosperous socialist country. Therefore, Chinese government are strengthening its legislation to build a law on the rule of law. So I think that domestically, this legislation is an effort made by the Chinese government to build a socialist country on the rule of law. Internationally, now the world is witnessing a fundamental change unseen in a century. In particular, since recent years, the United States has defined China as its most consequential geopolitical challenge. So we find that the US government impose more and more sanctions on the Chinese entities and Chinese citizens by its domestic law. Therefore, China needs such a law to guarantee its security and sovereignty and development interest. So I think that is the context, how we understand this law.
Right. Well, let me stay with you, Professor Huo. There are some other very important clauses in this law. For instance, Article 5 says the conduct of foreign relations by the People's Republic of China is under the centralized and overall leadership of the Communist Party of China. Why do we need to codify it in the law now? And what would happen if the foreign relations would not be under the leadership of the CPC?
Well, this article is a manifestation or embodiment of the Chinese constitutional law. As you know, that the constitutional law of China provides that the socialism is the fundamental system of the PRC. And the defining feature of socialism with Chinese characteristics is the leadership of the Communist Party of China. So this article is is a reflection of this article in the Chinese constitutional law to ensure that the Chinese foreign policy to be consistent and coherent and uniform. Otherwise, the country like China cannot safeguard that all the foreign policies are consistent. If you look at the United States or other countries where adopt the separation of powers, you will find that sometimes its legislative branch and the administrative branch, they have a contradicted foreign policies. So I think these reflects the merits of the Chinese system.
All right. We also have one more very important clause explaining the functions and powers of different organs. For instance, we have the central leading body for foreign affairs, quote unquote. We have the National People's Congress, which is the lawmaking body, of course. And we have the State Council, which is the central government. Which is the central functional government of the system, and then we have the Central Military Commission and also the Ministry of Foreign Affairs. Professor Huo, help us understand a little bit who does what in conducting foreign relations.
All these articles comes from the Chinese constitutional law, and the articles in the China's first foreign relations law makes more clear about the allocations of functions and powers of these different governmental agencies when they conduct foreign policies. So according to these articles, the National People's Congress, the State Council, the Central Military Commission, they all have their respective functions and powers to deal with foreign relations.
Let me go to Mr. He for some foreign relations related question, not so much on the legal front. I mean, this is also the first law to regulate the relationship between international treaties, international agreements, as well as China's constitution. How will it be connected now?
First of all, the China's foreign relations law is under the Constitution of the People's Republic of China. And the purposes for China's foreign relations should serve the three principles. First, to defend China's sovereignty and territorial integrity. Second, to safeguard China's national security. Third, to support and help promote China's economic and social development. Under these guidances, China joined international treaties and agreements. And in this particular area, China should support UN Charter and UN-centered multilateralism. So when China signs agreements, international agreements or treaties, we must follow these principles. And once China has signed these agreements, international treaties, we must abide by them without any hesitation.
It seems like non-question, but I mean, shouldn't it always be the case that, if you're not going to follow it, you shouldn't sign up to it in the first place? But why the importance of codify it in this particular law, Mr. He?
I think this is, in the past, people used to say that the foreign relations is a job of foreign ministry, and that's not correct. And because foreign relations, China's relations with the world, it should be guided and it should be led by the Chinese Communist Party. That's stipulated in the Constitution. Under this umbrella, we should do all fronts foreign relations because that is so important for China. China is not isolated in the world. It's a part of the world world society. And also, China supports world development and peace. So it's important. We must have the law to regulate and help support China's foreign relations activities in all various fields.
Well, let me go to Professor Svetlana Chini. We have seen stipulated in the new law the general principles guiding the conduct of China's foreign relations. It says that the law is to safeguard China's sovereignty, national security and development interests. It is there to protect and promote the interests of the Chinese people, build China into a great modernized socialist country, and to realize the great rejuvenation of the Chinese nation, promote world peace and development, and build a community with a shared future for mankind. Professor, how do you see these goals set out in the law? Are there any difference between these goals between other countries' foreign relations aspirations?
Yes, you have mentioned a variety of goals embedded in this foreign relations law, and of course it would be important to see how the achievement of all of these goals would be basically combined or balanced in practice. For instance, talking about measures that the state can take in order to protect its sovereignty, national security, and development interests. This is naturally an inherent right of the state. But for example, these measures would have to be then balanced with international obligations or international commitments that this state has taken, right? So, for example, just to give one example in relation to the measures protecting national security, these have to be balanced, for example, with obligations related to trade and investments that the state has undertaken through different international agreements. And normally these agreements will embed the clause about the essential security interests, which would allow the state to act accordingly, right? But of course, there would be a certain review of these measures. So far, we have seen the examples of this review in the World Trade Organizations, and we can see from these cases the common expectations of the countries, of the nations, that these security interests would be have to be genuine, right? So they have to be acted upon by the states, trying at the same time to follow their trade commitments, right? So all of these goals, all these objectives that you have mentioned are very important, but once again, it will be important also to see how they will be balanced together in practice.
Well, China also stressed the importance of a high-level opening up. For instance, the law says China develops foreign trade, actively promotes and protects in accordance with the law inbound foreign investment, encourages external economic cooperation, including outbound investment, and promotes high-quality development of the Belt and Road Initiative. It is committed to upholding the multilateral trading system, opposes unilateralism and protectionism, and works to build an open global economy. Professor Nolte, I wonder, what is your comment upon reading the articles in this law? What strikes you as being at least an interest in seeking balance in achieving China's own interests and achieving the overall interests of mankind?
Yes, I find that this law is an important clarification and codification of existing Chinese practices. I don't see any great departure from what's been going on so far for decades in Chinese foreign policy. There's no surprises here, but it is useful to have a comprehensive statement in a single law of the institutions, the lines of authority, and the broad principles guiding foreign policy. As we often say in English, though, the devil is in the details, because the various principles enunciated, which indeed are common to many states, if not all, also have inherent contradictions among them. So, for example, economic development may be aided by maximum division of labor and trade throughout the world. However, trade can also make a country vulnerable. So perfect national security, you might want to minimize any kind of dependence on foreign trade, and yet it's foreign trade that's brought great prosperity to China, now becoming the world's largest trading nation. So to some extent, there's a trade-off between the economic prosperity, for example, that trade brings, and the vulnerability that trading relations introduce, because now part of your economy is dependent on relations with countries whose systems and governments you don't control. So naturally, if they take actions that are adverse to Chinese development interests, there is a difficulty that may impact development or national security. So economic development is a positive thing, and it is aided by trade and investment, but those trade and investment relations can also introduce national security problems. So it's always going to be a difficult balancing act.
Professor Huo, what is your reaction to such concern? And do you see the emphasis or the kind of effort China is taking to balance these very important interests. On the one hand, economic and trade interests. On the other hand, national security interests, but also respecting domestic laws and international law and norms that are widely recognized, and also international treaties and agreements China has signed up to. How committed is China to respecting all of these different rules and regulations?
As you mentioned just now, this is a comprehensive law in foreign-related areas, and in this law, China tries to, manifest its intention to the outside world, that it tried to, balance all these goals. On the one hand, China upholds the international system with the UN at its core and international order underpinned by the international law. Therefore, China, in this law, manifests that it opposed unilateralism. On the other hand, China also says that it will strengthen its high-level development economy and will conduct the open door policy and more deepening its reform. And in the end, China, in this law, manifests its intention that China will safeguard its security and sovereignty and develop interest by rule of law. So generally speaking, I think that this is the law that China tried to send a very clear signal to the outside world that China tries to uphold the international law and also safeguard its national interest by rule of law.
In terms of that, let's take a look at some specific articles. For instance, Article 32, it says that China shall strengthen the implementation and application of its laws and regulations in foreign-related fields in conformity with the fundamental principles of international law and fundamental norms governing international relations. It also says China will take law enforcement, judicial, and other measures to safeguard the lawful rights of Chinese citizens and organizations. Mr. He, what does this clause mean, and what are some of the possible scenarios that this article can be applied?
I think this article is very important and closely related to almost all the entities and individuals engaged in foreign relations and the foreign relations or foreign investment, foreign trade, and people-to-people exchange activities. We know that the developed countries, almost all of those developed countries have very sophisticated legal system to protect the interests of their families, citizens, and businesses. So China's foreign relations law is doing just the same. We should upgrade our protection to the interests of our business and the people in different areas, especially in trade-related investment or national security-related matters. So that we should firmly protect our interests. On the other hand, we should not blindly protect. We should strictly follow the law, do what the law has allowed and what is compatible to international practices.
Mr. Svetlitsky, how do you understand this clause? And also in relation to an anti-foreign sanctions law that was enacted in 2021, what's the difference and connections between the two laws?
Yeah, so as you have rightly mentioned, the foreign relation law basically refers us to the possibility of adopting certain reactive or countermeasures to protect, for example, national security interests. Now, it should be stated that this reference to counter-sanctions does not really introduce anything new because China already from 2021 had an anti-foreign sanctions law. One of the features of this law is basically its reactive nature, so it's a reaction towards the action of others, and also the opposition towards so-called long-arm jurisdiction. Basically, the national law should be applied when there is a certain connection to this country. So, for instance, China would apply this law in relation to activities happening in China, including to foreign persons and entities, but those who do some kind of business activities in China. So already from 2020 and 2021, there are some rules, for example, countering the sanctions of other countries, opposing this extraterritorial application of sanctions, and also certain provisions that are applied to foreign entities, for example, that are doing business in China, but for different, for example, political reasons, they discriminate or interrupt normal business relations with the Chinese companies. So all of these rules that have been already adopted, they provide a mechanism for adopting the counter-sanctions. And basically this law on the foreign relations provides a certain kind of a basis, a ground for it. Because if we would look at China's national security law that has been adopted some years ago, it did not have a mechanism for imposing counter-sanctions. So in this sense, the foreign relations law, so to say, closes this gap and provides a legal basis for these mechanisms, which already exists. China has so far been quite cautious in using these mechanisms, and we can see only very few rare examples when these mechanisms have actually been used in practice.
You have mentioned that China has been cautious in using these tools. What do you think are the reasons? And also, with the enactment of the new law on foreign relations, do you think foreign investments or foreign businesses trying to operate here in China have concerns to deal with?
My understanding, the reasons for this cautious approach was not so much lacking the rules or lacking the legal basis, but rather the economic reasons, because always when such restrictive measures are imposed, they can trigger a response on the other side. So in this way, China has been quite cautious, even reacting on certain measures taken by other countries. And this also basically addresses the second part of your question: how this is going to be, what kind of effect is going to have on foreign business or foreign investments in China. As we discussed, having the rules doesn't necessarily mean that they will be always applied in practice or actively or assertively applied in practice. There are also different economic basically rationale by not using them assertively, and taking account of some other steps that China did, as we mentioned, unilateral opening up to foreign investment, also signing trade and investment agreements with other countries. We can see the commitments for keeping this opening up. So all of these measures that we mentioned today, they will be basically sort of providing a balance on the security part, allowing to take security-related measures when it is absolutely necessary. That is my understanding.
Professor Nolte, I wonder, what is your reaction to Mr. Svetliciny's answer? It's very interesting because Article 33, which is also closely watched by the international media, stipulates that China has the right to take, as called for, measures to counter or take restrictive measures against acts that endanger its sovereignty, national security and development interests in violation of international law or fundamental norms governing international relations. What do you read from the wording of this sentence? I'm seeing, for instance, here, it says China has the right. It doesn't say that China shall. Do you think there is a certain reservation there, or that the intention is to send out a certain deterrence rather than a strong declaration of intent to act?
Yes, I would agree with the professor's comments. He has outlined very well the fact that in many cases, China's measures, for example, during the Trump's trade sanctions against China starting in 2018, China did impose counter sanctions, but they tended to be less severe than the original sanctions that the United States had imposed. And so I think the fact that you have the right under international law in some instances or in domestic law to respond doesn't necessarily mean that there are not reasons for restraint, because any action itself has consequences. And so a government has to carefully measure, is the countersanction or the action by the government going to be so provocative that other states may react even more strongly and therefore jeopardize China's relations worse or create a downward spiral of tit for tat. So far, we haven't seen that kind of aggressive sanctioning and counter-sanctioning. It's been relatively small scale, except for the trade war that began with Trump in 2018. But I think the potential is there, and it's largely, as I say, the details of implementation that matter the most, because the fact that the powers are there doesn't necessarily mean they need to be exercised or would be exercised.
Okay.
China may indeed implement this in a cautious way, and I think to some extent the foreign press is overreacting to this law, because it seems to me that it restates things that have already been common practice, but it does clarify them.
Okay. Professor Huo, very briefly, is China going to roll out more laws for the conduct of its foreign relations?
Well, I think the answer is yes. I think China is now strengthening its legislation in foreign-related areas in this world, which is, witnessing a momentous change unseen in the century. So I believe that in the future, China would legislate more law in foreign-related areas, such as the law on protection of Chinese interests overseas and the laws on the foreign, let's say, foreign assistance and so on. That is also, conformed with the Chinese goal to build a socialist country under the rule of law.
Mr. He, how will this law impact China's relationship with the world, with the developed countries, which have seen China increasingly as a rival or competitor, and with the other developing countries which are looking up to China in a certain way?
Well, yes, that's very important. We see that the White House released a national security strategy last October, saying that identifying that China is the only power with both the will and ability to challenge the rule-based international order, so as to pose the gravest challenge to the United States. So our Foreign Relations Act, just released, has made it explicitly clear that China supports both international order. That's centered with the United Nations. That's based on the objectives and the principles of the UN Charter of the mutual respect of the national sovereignty and the territorial integrity, mutual non-interference, mutual non-aggression, and equality and mutual benefit, peaceful coexistence. These are the rules based on international order. We admit those international relations with the United Nations at the center, so we can talk with the United States and with the developed countries. We should base our relations on these principles. And also, this is a good suggestion for the developing countries, that we should also enact foreign relations laws so as their foreign relations could keep consistency, not to be changed from time to time, so as to make a stronger voice that we all respect United Nations and UN Charter, so as to form a greater cooperation in the world.
Yeah, all right. Well, the English text of this law can be found online via the portal of the official news agency Xinhua. Many thanks to my guests. With that, we come to the end of this edition of The Point with me, Li Xin. As always, you can follow me on Facebook and Twitter using the handle Li Xin in Beijing. On behalf of the whole team, thank you for watching. You've got The Point.